Hi there, I'm Simon Bennett from OMB Solicitors and welcome back to the OMB Law Board. Today I've got Juliette Nairn, our body corporate partner here at OMB. Juliette, welcome back.
Thank you very much for having me.
So Juliette, body corporates are a fantastic mechanism, and as our population grows and housing affordability becomes more and more an issue, the growth of strata living or community living is just going through the roof, and it's going to become more and more prevalent.
Yes, that's exactly right. So in March, we just had Strata, which is our Strata conference, so the industry conference in Queensland. We are only going to get more diversified living and vertical living in terms of that. And so Strata is not getting smaller. It will only get larger in Queensland.
Yeah, I agree. I think the future of property is the development of more and more strata because we're fitting more people into less space. There's less greenfield sites to develop. There's less land released, particularly around southeast Queensland.
Yes.
So with that being said, there are problems associated with community living. We get a lot of people living in a smaller space.
A very close space. We actually do a little bit of a joke sometimes when we talk about strata because we say the only place you live closer to each other is in prison.
I've got no comment on that one, but I think that's true. So with so many people living in such close proximity, it is inevitable that there will be disputes. It is inevitable that there will be conflict.
That's right.
And you would see that all the time.
We do. So particularly with disputes, with body corporate, and particularly in Queensland, we have our Body Corporate Commissioner's Office. So at first instance, they have exclusive jurisdiction with respect to disputes. What happens there is body corporates are required and individual lot owners are required to do self-resolution. So you must try and resolve the dispute yourself at first instance. Then the second step is an application for conciliation in the Commissioner's Office. That's exclusive jurisdiction for the Commissioner's Office. And then it might go to a paper assessment, which is like adjudication. But in terms of where a lot of our large disputes are placed, there is one area that the Commissioner's Office will not deal with.
What's that?
They do not deal with debt disputes, which is levy recovery.
Okay, so as we know from a previous episode of the Law Board podcast, levies are the lifeblood of a body corporate. They're the money that gets collected to keep things rolling.
Very important. So we're not a bank. The body corporate's not a bank. You have everyone else that has financial resources or financial independence to go and borrow money. The money a body corporate uses comes from the levies raised by individual lot owners.
Okay, so if a lot owner doesn't pay, how does the OMB body corporate team help the body corporate recover those levies?
That's right. So in terms of that, we look very carefully. Now, one of the things as part of the education of that with committees is, yes, this is people's homes, but sometimes the committees want to let the levies run out a bit. So they don't want to recover them straight away. They want to give people an opportunity. Giving an individual lot owner the opportunity to pay their levies once the due date falls past is actually the worst case scenario because of the penalty interest that applies. So you've got contributions, which is your levies, and your penalty interest. And the penalty interest is very high. It's the highest penalty interest that we have in Australia that applies to debts. So the starting point is OMB will touch base with the committee, and once one levy period goes by, the body corporate management company will do an internal debt recovery process. If that's not successful, then it gets referred to OMB Solicitors and we send out a letter of demand, but we go by text messages, email, tracking the individual down and communicating with them of the fact that, hey, you live in a body corporate and you need to pay levies. Now, if I'm a first-time lot owner, I don't know what a levy is. Despite the fact that there's welcome letters and all of this information, they need education. So we have a good chat on the telephone and then usually we can get everyone on the same page and the levies start being paid again.
Okay, but what happens if they still don't pay?
So then we have to file court proceedings in the magistrate's court. So they're personal proceedings that are served upon the individual or served upon the corporation, depending on who owns the lot. And then there is an opportunity in terms of that for them to file a defence, but you can't really defend the non-payment of levies. It's a statutory debt. And then we recover it by default judgment and look at enforcement. Now, enforcement is the key issue because no one wants just a piece of paper. You need the money in the bank account. So enforcement is the appropriate approach that we take, and we try to get to judgment as quickly as possible. How do we enforce levies? Often a lot owner will have a mortgagee. If you have a mortgagee on your title, it's actually a breach of that mortgage not to pay your levies. So we will write to the mortgagee and we will talk to the mortgagee about the extent of the debt. And because they're a financial institution, they will step in to pay that debt. Now, there's a reason why they step in.
Okay. I know what you're getting at here because we're at OMB, we were certainly at the cutting edge of creating the law in this regard.
That's right.
There's a reported decision, so I think we're free to talk about it here, but
yes.
Reported decision of Prinz.
That's right. So it's actually, body corporate for Wave, Westpac Banking Corporation, but the individual lot owner was a gentleman with the name of Prinz. And there was a number of cases which are reported decisions associated with it. Why was Westpac Banking Corporation involved? Because Westpac Banking Corporation, as the mortgagee, said, no, we're only going to pay the levies. We'll pay some of the penalty interest, but we're not paying the reasonably incurred recovery costs when we had the individual lot owner not pay the debt.
So it's a bit of a backfill on that. You went, we had a lot owner who had levies which had become in arrears.
Yep.
There'd been substantial costs associated with recovering those arrears.
Correct.
And you had approached Westpac Bank to say, hey, this is problematic.
Yes.
You should enforce your security because the costs and the levies are starting to eat away at the bank's equity.
Correct.
In the property.
Yes.
And the bank pushed back and said, no, it's not eating away at our equity. The levies are in the interest, but the costs come after our mortgage.
Yes. That's exactly right.
That's the background.
So that's the background. So that was the argument. We had to have that argument. Westpac actually sued the body corporate for Wave, originating application in the Supreme Court, and the body corporate was successful to say, no, it forms part of the body corporate debt, so it takes priority with respect to that, and the mortgagee was aware of it at the relevant time. The Westpac actually appealed us. So we then went to the Court of Appeal, and the body corporate was successful. So the body corporate was able to recover the full amount of that debt.
So what that seems to have done is created fairly accepted law that a lot owner who doesn't pay their levies is responsible for not only the levies, but the interest and the recovery costs associated with getting that paid.
Yes, and all expenses associated with that reasonably incurred. So body corporate management expenses, administration expenses, and legal expenses. So it's quite wide, that definition.
So practically what that's allowed you to do in the recovery process now is go to a lender a lot earlier.
Yes, a lot earlier in the process with the case law backing that up. Obviously, we do have situations where some lots don't have mortgages. Particularly think of the circumstances where you might have inherited a lot, but you may not have any income coming in, so how do you afford to pay for that lot? That's actually quite a tricky one in terms of enforcement and recovery. Unfortunately, in those circumstances, we use a lot of different options, including welfare checks by the police, charitable organisations who assist, and the bailiff at the courthouse for seizure and sale of a lot. We don't really want to be selling individual lot owners, of course, in terms of that.
Last resort.
It is a last resort. In the circumstances that we've had to do it, though, where we are a bit deemed the big bad body corporate, then those individual lot owners have actually contacted us later and said it is the best thing that happened to them because they were able to realise their asset, move into a aged care facility, retirement facility, those sorts of things, where they've then been able to create relationships.
So the key takeaway is community living, you have to pay your levies. There is very strict mechanisms that allows the body corporate to recover your levies if you don't, and ultimately you will end up paying more through that recovery process. So
yes.
I think the takeaway is to pay your levies when they're due. Now let's talk about a couple of those other disputes really quickly and how we resolve them. What about the general disputes where two lot owners don't get on, one may defame another, animals, smoking, car parking, all those sort of general stuff we've talked about before?
In terms
how
of
do we resolve all those type of disputes?
The Commissioner's Office is the first port of call with respect to that. Regarding defamation, that actually sits outside the Commissioner's Office because obviously that's civil proceedings with respect to it. We would hope that most people would live in harmony. We don't want defamatory statements being made. Regarding that, though, an interesting point to make on it is a body corporate record is actually a record, a proper record. So in terms of, so if I recorded you as not paying your levies, that's a body corporate record. That's not a defamatory statement. And it's also true in terms of the circumstances of that. But we do get a lot of individuals who get upset with respect to that. How do you minimise that from a defamatory perspective? Use lot numbers, don't use names. See, little tricks of the trade to learn in terms of that. Pets, Commissioner's Office, bylaw disputes, Commissioner's Office, enforcement of bylaws, go to the Commissioner's Office or to the Magistrate's Court with respect to that. Prefer to keep them in the Commissioner's Office because the Magistrate's Court probably gets a bit sick and tired of seeing bylaw disputes.
So the OMB body corporate team has the ability to help body corporates with all of those types of dispute and resolving them through that process.
Yes, and resolving them very successfully at a conciliation stage. So don't set aside conciliation. Conciliation does work, and it does work in the Commissioner's Office.
And the great thing about conciliation, I hope you'd agree, is you control your own destiny and you can get resolutions that you couldn't get at a determination.
That's exactly right. I have been to a range of conciliations where we thought, oh, this is not going to resolve. But once people actually start talking about it and an independent person's able to assist, you get an outcome.
Yeah, fantastic. So complicated, not going away. These community living arrangements are only going to increase. So I think, our listeners and viewers would have found that extremely informative, as did I, Juliette. So thanks for coming in and helping us with understanding that today.
That's right. That's what we're going to be talking lots about, understanding strata.
So if you need to understand strata and you've got questions for Juliette or the team, drop us a line, and we look forward to seeing you again on the OMB Law Board.